Thank you. You may be seated. Good morning and welcome to the First District Court of Appeal. We have one case on our oral argument docket this morning. Case number 24-2730, Sean Russell versus the Florida Department of Corrections. Appellant's counsel,
Yes, sir.
When you're ready.
Thank you. Good morning, and may it please the court. My name is Luke Newman, and I would like to reserve 4 minutes of my time for rebuttal. Yes. Your Honors, I want to start out by arguing, probably where my brief should have started out, my initial brief at least, and focusing on the trial court's limited powers to intercede on an arbitral award. The statute, I'm referring to Florida Statute 682.13, specifically limited the trial court from interceding into an arbitral award unless the trial court could find and support very rare specified circumstances. Those very rare and specified circumstances were fraud, undue means, partiality, corruption, misconduct, refusal to provide notice, or an arbitrator who exceeded his or her powers. And this is by design and to prevent the arbitration process from becoming just a preliminary step in litigation. Arbitration cannot be a true alternative to expensive and time-consuming litigation if one party adopts what the courts have referred to as a never-say-die attitude and starts viewing the arbitration process as simply the first step in what's eventually going to turn into a lawsuit. And this is supported by decisional authority from both the United States Supreme Court as well as this court and the Florida Supreme Court. An arbitration award, a decision...
So I think, didn't Judge Dempsey find that the arbitrator exceeded his authority in this ruling?
That's correct.
Okay.
Yes, sir, Judge Robertson. That's the only basis that's argued here. What I was doing when I was going through the specified circumstances in the statute, I'm emphasizing those to show that these are limited, rare circumstances, and that
I think we follow you that the court has very limited authority to go behind what the arbitrator does. But,
yes, sir.
But in this case, she held that he exceeded his authority. And I'm trying to figure out, was it his authority to consider mitigation at all, or was it his authority to consider mitigation under this CBA?
Judge, and maybe I'll let my colleague from the state address
Okay.
the justification for the lower. Obviously, I'm representing the appellants. I'm arguing and presenting the court that the order on appeal needs to be overturned. So maybe I'll let my colleague from the state address that issue, what the justification is behind the order that I'm arguing and presenting you today needs to be overturned. But let me emphasize what the U.S. Supreme Court says, that an arbitral decision that even arguably construes or applies the contract must stand regardless of the court's view of its merits. And so I want to be clear in wrapping this point up. The trial court's not free to say, I dislike the logic of the arbitrator's award. The trial court's not free to say there is sloppy language in the arbitrator's award. When the arbitrator addresses an issue in an award that even arguably construes or applies the contract, then the arbitrator's award must stand. And the first, yes, sir.
Sorry, if a collective bargaining agreement said that employment disputes go to arbitration, however, the arbitrator is not authorized to consider or modify the employer's proposed penalty.
Yes, sir.
If they did so,
yes, sir.
Which, I know that's not what the CBA said here, but that's pretty much the state's argument is what happened. Isn't that exceeding authority by, in fact, modifying the punishment?
So I think what you're referring to, Your Honor, would be what I've referred to in my briefing as a Lake City collective bargaining agreement. And I call it a Lake City collective bargaining agreement after this court's case in Lake City. And if the collective bargaining agreement strictly limits the mitigation of discipline, meaning specifically carves it out, in Lake City, this court back in 2018 said that the mitigation of penalty would not be allowed if it's specifically carved out in the language of the collective bargaining.
Yeah, so the CBA at issue in Lake City seems like it specifically prohibited the arbitrator from mitigating the punishment. Here's the language. In the case of a grievance arising from a discipline, the arbitrator does not have the authority to alter, amend the discipline, but only determine whether the employee engaged in the misconduct alleged. So that's very limiting.
Correct.
We don't have that here.
Correct.
Okay.
Correct. But so I agree with you there 100%, Judge Roberts, and then let me back you up one step to Rayner, which my brief relies upon extensively. In the Rayner case, which is from this court from 2008, What Rayner stands, the proposition in Rayner is that even if there was some other portion of the CBA, that a collective bargaining agreement, that could be viewed as contradictory, that the concept of just cause, the concept of mitigation of penalty is so strong that even if there was some other language, and there's none in this CBA, okay? This CBA says just cause. In fact, this arguably, and maybe I'll get into this in a second, goes further. But even if we could find some other language.
There's a case out of the second that says that just cause encompasses mitigation also, right?
Correct,
Okay.
correct. And so, but I think that in being honest with you, Judge Roberts, that maybe this just cause concept, because it's a term of art, all right, it's a nuanced labor law term of art, then maybe this kind of has taken this case into us maybe staring at the tea leaves too closely. Because this order should be overturned without even any reference to the just cause concept, because the collective bargaining agreement in this case references cause as defined in Florida statutes at 110.227. And 110.227 allows for, when addressing in this case obviously involves a disciplinary matter related to a correctional officer. And 110.227 says a correctional officer, in a correctional officer case, the discipline can be mitigated. So without getting into the nuance, all the history behind just cause, I think it's good law. It comes from this court, it comes from the Florida Supreme Court, it comes from U.S. Supreme Court. But I think that even what I'll refer to as
my understanding of the arbitrator's ruling in this case is the arbitrator did not say that the punishment was excessive compared to the offense. He said that because of the time frames, because the department waited too long, that's why he was going to throw this out. Not because he made some kind of determination whether the punishment was too hard, but that they waited too long.
right.
And a quote to add to that, any mitigation for a lesser penalty would not be warranted, is what the arbitrator said. So this isn't a mitigation case, it doesn't seem.
Oh, sir, I don't want to disagree with you this early in the morning, but I tend to disagree with you on that point. My clients do. The arbitrator said, what the arbitrator said that I think has caused some confusion here, is he says that just cause, and then he mitigated the discipline that had been imposed. So discharge was imposed.
But he mitigated it based on the fact that it took too much time in his view.
In part, yes, sir. Yes,
Okay.
sir, in part. And that brings up
Well, and Chief Judge Osterhaus just read the operative part that said, on the merits, he wouldn't have said that he wouldn't have mitigated.
Any mitigation for a lesser penalty would not be warranted, is what the arbitrator said.
But then doesn't he?
But then he goes into the due process part, and basically, I mean, it smells to me like a suppression-oriented case. Because the department did bad, I'm going to punish them. And so it had nothing to do with whether the penalty was just, whether that penalty was a legitimate penalty, or whether that penalty should be mitigated. It had to do with the department taking too long, and therefore, in his view, and therefore I'm going to punish them.
I think that's part of the reason. I would also point, if you look at the arbitral decision, the opinion and award, there's also a lot of discussion in there about the issues that the client was going through at the time of the incident. So I know in the summation, he talks a lot about the time lapse in seeking a dismissal, the 6 months of inaction, followed by the demand for immediate dismissal.
And I want to come back to that too, because
Yes,
that
sir.
seems to conflict with statute.
Yes, sir.
180 days, 6 months, but go ahead.
Yes, sir. And so in doing that, in evaluating those two positions, he discusses in the award, the opinion and award, he discusses the lack of action for 6 months, followed by this demand for an immediate discharge for the sleeping offense. But I don't want to limit the the explanation of the arbitrator's mitigation to simply the time delay. I think if you look and focus a little more closely on the earlier parts of the opinion and the award, you can see that it appears from what we have in the record that the arbitration involved a lot of discussion about what the client was going through leading up to that, medically, leading up to that incident. The incident gave rise to
But then he
discipline.
rejected all of that.
He seems to. He seems to. But
Well, yeah.
but let me say this.
And
But
then on the day that your client was caught sleeping twice, he didn't bring up the fact that he was on medication to his boss. He didn't say, "I'm sorry, boss, I'm taking this thing that makes me tired." It was months later.
That's fair.
When they filed against him. That he
That's fair.
Comes up with this, yeah.
That's fair, and I'll accept that. But let me say this. Whether the court thinks that his decision was legally correct or equitably correct is irrelevant, because the parties in this case have bargained for the arbitrator. The parties in this case, they entered in the CBA and said the arbitrator decides, this rotating, randomly selected arbitrator decides. So whether, I think we could all, as legal readers and legal decision makers, maybe read what was written and say, well, I disagree with that, or that gives me pause, or I'm not comfortable with that.
Well, I think your point is well taken, that sitting here, or Judge Dempsey can't dispute the factual determinations made by the arbitrator.
Yes, sir.
Okay.
Yes, sir. And I don't think that we can dispute, I don't think the legal decision maker could dispute the outcome either. When he's evaluating just cause, the term of art, which he's saying this allows me to mitigate the discipline imposed, he's interpreting that contract. And the contract says the contract itself says he gets to interpret that, or she gets to interpret that contract, not a judge later on down the line.
But the CBA also says that he can't do so in a way that's inconsistent or that conflicts with applicable law or the CBA, correct?
Right. Right. But then the CBA says,
So there
just.
are some constraints.
Yo,
like
certainly.
Statutory
Certainly.
constraints. And,
I think
he couldn't mitigate on the fact that he has brown eyes, therefore I'm going to mitigate.
I think that would be problematic. And I think also if he were to say something that would to somehow limit, let's say, the employer somehow, and say any sleeping on the job offense can only be dischargeable after a warning or something along those lines. I think if he were to try and impose some kind of standard that needed to be applied moving forward, I think that would be problematic as well.
Could you address for me Section 112.532, the statute that was mentioned in the answer brief, but wasn't cited in your reply brief that I saw, and this provides a limitation. And I'll give you extra time. The section is entitled "Limitations for Disciplinary Action," and it gives the department 6 months from the date of the incident to notify, in this case, Mr. Russell, that this is going to go forward. Here, that time period was 2 months, and the whole thing was done within 6 months. So it looks to me like there's a conflict between what this arbitrator is saying, because this wasn't done in 6 months, when the statute says that a subset of what happened here needed to be done within 6 months, not the whole thing.
I don't think that I made the argument that the delay violated the statute in any manner. I want to be clear. I think that was the arbitrator's language that I guess has given rise to the dispute here, was a juxtaposition of those two positions, that you didn't do anything. You gave him the notification after 6 months that you wanted him terminated immediately, but in the interim, he's been working for 6 months in this position of trust. He's armed at some points.
The statute gives 6 months, and here they notified him within 2 months, according to the arbitrator.
I think that the dismissal, the demand, there's a predetermination meeting, and those things happen after about 2 months. And I think a dismissal, we need you dismissed, you're off the job, you're fired, happened 6 months in. And I think that
But it seems perfectly consistent with the statute.
Certainly.
It addresses a limitations period for this situation.
the statute was not.
So why isn't the statute, what the arbitrator did, in conflict with the statute that gives you 6 months?
Well, the
If
statute-
the arbitrator to say 6 months, because that 6 months is a penalty, it's worthy of a penalty.
The statute was not violated. That's not a position the appellants take this morning, sir, or throughout this appeal. The statute was not violated. The arbitrator's focus on the time delay, I think, was his juxtaposition of the positions, that if you really wanted him fired, you thought he was a threat to your security, the institution, your operation, why is he working there in the meantime for 6 uninterrupted months?
Well, and their answer will be because the statute gives us 6 months.
I think I think they could have fired him the day after. They got 6 months to move, but I think they could have said the day after, here's your notice, we want to terminate you. And instead of doing that, they waited for 6 months and then said.
But the statute gives them 6 months.
Correct.
Okay.
I see I'm well into my rebuttal time, so I will yield.
And let's add a minute to each side.
Good morning, Your Honors. Jason Muehlhoff on behalf of the Department of Corrections. Under Florida law, a circuit court shall vacate any arbitration award for exceeding the
So you
arbitrator's
have to agree
powers.
that you don't have a Lake City type CBA here. You'd be in a lot better place if you had the Lake City CBA, right?
So Lake City does make abundantly clear or explicitly clear the power of the arbitrators, but each CBA is taken on its own terms.
Sure.
And we think that the CBA here, plus the relevant regulations, lead to the same
So when
conclusion.
Simmons, the second DCA, said a CBA like this that didn't discuss mediation at all, that mitigation at all, that mitigation was included in the analysis of just cause. Do you think Simmons was incorrect and we should not follow it? Do you think Simmons was correct, but this is a different situation? Explain how you deal with Simmons.
Yes, so Your Honor, I think it's clear that each CBA is ultimately a contract, so you have to take it on its own terms.
Sure.
And so here, this is admittedly a long answer, but I think there's 4 separate sources that get you to the same conclusion under our collective bargaining agreement, that there is no power to mitigate after finding just cause, or to impose, not even mitigation, or to impose some other requirement. So the first, I would say, Florida Administrative Code, Rule 60-L36, and that says each agency has primary authority and responsibility for managing its employees and may impose any discipline up to and including dismissal. So I think that establishes the baseline. An agency can fire their own employees if they determine it's necessary. So the burden then becomes on them to show the arbitrator having some delegated authority to walk that back. But under our arbitration agreement, there is clearly no explicit clause saying that the arbitrator can do that. And of course, if you need something
They're
in
saying
there,
that that's included in just cause.
so certainly is, Your Honor, but just cause, what any of those cases and all of those cases I think make abundantly clear is that after finding just cause, you cannot then go on to disrupt the agency's determination. We do agree that it's a term of art, but we cite a wealth of federal appellate courts that explain this. Once an arbitrator finds there's just cause, that's the end of the inquiry. And ironically enough, or interestingly enough, I should say, record page 75, Winters appears to agree with that. The way he frames the issue is whether the
So your
Florida-
view is just cause is whether the agency has established that they had the authority to administer discipline.
have they met their burden under the facts? Have they proven that what happened in terms of the misconduct, and does it fall within the regulatory scheme? Both of those,
And
I
they
think,
don't have the authority to go beyond that, saying, yes, he committed this violation, but the penalty was excessive for some reason.
Yeah, exactly. And again, these are defined by regulation, and the first instance of sleeping on the job warrants dismissal, suspension, or one other thing. But the second, multiple violations, as what happened here, the only option is dismissal. So I think the department has clearly met its burden as applied to Russell here. But if I can finish the other parts that I think also point to why the arbitrator here wouldn't have the ability or authority to impose or alter the punishment after finding just cause. So the second one was nothing in the CBA. And again, the preamble says that this sets forth the entire agreement. So I think we can assume that the CBA is the 4 corners of an arbitrator's powers here. The third one, this is from the CBA itself, page 30. It says, and Chief Judge, you already pointed out this part, the arbitrator is without power to make any decision that is contrary to, inconsistent with, adding to, subtracting from, or modifying the terms of the CBA. Clearly, we think that he did that here, both with his first decision to find just cause but to change, but maybe more explicitly to impose this extra textual notion of due process that is found nowhere in the CBA or in any of the relevant statutes. And then fourth and finally, it is the statute 110.227, and that is PERC being given the statutory authority to mitigate damages upon a finding of writing. What that makes clear is at the beginning under the CBA, you can choose to go through the PERC option or you can go through arbitration. PERC is specifically given the authority to mitigate. So we think it's a relatively standard application of expressio unius to say, if one path has this authority explicitly delineated, the other authority doesn't make any mention, therefore that omission is relevant. So I think any and all of those 4 pieces, Your Honor, get you to the point that the arbitrator did not have the power to do what he did here. Certainly happy to talk about the due process angle or anything else, but
Well, what is your view of 112.532? That seems to, this is the limitations period for disciplinary actions. It seems to give the department 6 months to investigate, so that there's a notification requirement after 6 months. And here, the arbitrator, because the whole process, not just the investigation period, but the whole process took 6 months. He's saying that that's problematic.
Your Honor, you had mentioned this with my friend on the other side. The statute is clear that the department complied with all of the regulations here. 180 days to give notice of the disciplinary action. The department here did it, in 2 months. And there's a bit of an irony in that the arbitrator punishes the department for having due process or allowing the arbitration process to run its course, to have the predetermination conference to allow it to go through the multiple steps and eventually get to arbitration. The department here was trying to make sure and check every box that it felt like this was the right decision. And again, being punished for that when the statute allows for it simply doesn't track. Happy to answer any other questions. Otherwise, the department respectfully requests that this court affirm.
Thank you. Mr. Newman?
Your Honors, I'll go through the four points that my colleagues mentioned relatively briefly here. Yes, Chapter 60 of Florida Administrative Code essentially says that these agencies can fire at will. However, in this situation, the parties were controlled by the collective bargaining agreement. They've entered into this contract. I've cited back to the federal authority that the department has relied on. A lot of the federal authority that they've relied on is no longer good law, and they've relied primarily on this case from St. Louis from the 8th Circuit. It's called Northern States. Northern States was written with a dissent in which the dissenting judge in that case wrote, "The just cause is in arbitration and labor management relations a key term of art. In the concept of arbitration review, it's a bargained for term. The just cause concept includes the ability of an arbitrator to mitigate the imposed discipline." My colleague mentioned the Chapter 33 issue with the sleeping on the job penalties. Well, there's a list of penalties. It doesn't say if you get caught sleeping on the job or we think you've slept on the job that we terminate you from the jump. There's a list. And then let me talk about this perk idea. The collective bargaining agreement itself says that discipline shall be imposed as is listed in Chapter 110.227. That chapter, the chapter that's cited in the body of the collective bargaining agreement, says that correctional officer penalties may be mitigated. And then the collective bargaining agreement, as we've discussed, said that there are these two tracks. And it says that this is the agreement except any exclusions that are noted within, I'm going back to the CBA here, the collective bargaining agreement itself. There's no exclusion in the collective bargaining agreement saying if you want mitigation, you have to go to PERC, that you cannot go through arbitration. So the concept of mitigation of discipline is engrafted in the cause language of the collective bargaining agreement itself. Without any questions on other points, we'll be happy to rely on our briefing. Thank you so much.
Thank you, Mr. Newman. All right, that concludes our oral argument session for this morning. We are adjourned.